see. All right, we've got some participants joining here. So let's see, we'll give it a minute and then I'll start us off here.
Perfect.
All right. Oops. Okay, well, here we are. We are at the top of the hour, and this is Estate Planning 101. And I cannot tell you guys how excited I am that you are here and a part of this. I know that estate planning and being on a webinar is not the first thing that we sign up to do on our lunch hour. So I commend each and every one of you for being here and just being a part of this. This is something that's been on my heart for a while and that I've wanted to be able to share with just all of the people that have supported me over the years. And I hope that you get as much value out of it as I think that you will. One of the things I know, so estate planning is one of those topics that either you want to talk about or you just want to avoid it altogether, because it kind of brings a sense of, well, you know, part of estate planning is you got to have a will, you got to have a trust, and we all know what comes with all of that. And so I always get the sentiment that people just like want to avoid it completely. And I know that personally, I was entering into my 40s before my wife and I decided to get our estate plan in place. And it really didn't happen until I sat down and had lunch with somebody who said, and we weren't getting together for estate planning. It was more just, let's get together, catch up. And then there was oh, by the way, do you have an estate plan in place? And my response was, no, not really. I don't really know what that means or what's goes into having an estate plan. I mean, I know that there's a will and so forth, but it really kind of lit a fire under me, and it pushed me to get more information and find out what is an estate plan. And I think for my wife and I, the deciding factor was we have 3 young kids, and God forbid something happened to her and I, and our kids are left to figure things out. Now we have family and so forth, but the reality is if you don't have the proper documentation in place, then there's only so much family can do. And so we wanted to make sure that our kids were our first priority when it came to putting together our estate plan. And once we got the estate plan in place, I started having this conversation of, why don't more people have an estate plan in place? And just having these questions pop around in my head, and I just kind of came to the conclusion that while there's a lot of information about estate planning, there's not a lot of awareness of the importance of an estate plan. And like I said in the beginning, a lot of people tend to shy away from the conversation. The other thing is that, in some cases it can be really expensive. And so you're faced with the decision, do I go on this elaborate vacation, or do I, put together an estate plan? And so maybe it gets pushed to the wayside. The other part is that I think some people, and this was probably the same case for me, was we just think we're invincible, and we think we have plenty of time to put together an estate plan. And the reality is that when you need that estate plan, it's too late. And so I'm really excited because we are joined today by Jeannie Bruins, and she helped my wife and I personally to put together the foundation of our estate plan. And I say that because an estate plan is something that you want to establish and then maintain for years to come. And I think Jeannie will probably cover all of that. But the thing I loved most about working with Jeannie is that she asked all the right questions and pulled out the information from us, and helped to empower us to make the proper decision in putting together that estate plan. So I'm really excited to see what she has to say today. And Jeannie, if you would, I'm going to switch the screen here. There we go. Take the next minute or two and just tell us who you are, give us a little background, and then we'll dive into the content.
Okay. Thank you, Josh. First of all, I'd like to thank you for giving me this opportunity to reach your audience, to talk about something that I love. I am Jeannie Bruins. I am a legal document assistant. I am not an attorney. I came out of the paralegal world, and I've done estate planning for 32 years. I was trained by a very qualified attorney and worked for him for a while. And then he moved out of the area, so I went out on my own and found other attorneys to work with. And then went on staff with another attorney back in the early 2000s and was with him for about 3 years before going out completely on my own. And what happened during that time frame is the law changed. Prior to 2000, the definition of a paralegal was very ambiguous. And so the business the business code basically changed in 2000, and it defined a paralegal as a legal professional who must work under the direction of an attorney and cannot work with the public directly. And it created the designation of legal document assistant. And we are legal professionals who can work directly with the public. We can do all the document work that an attorney can do. And however, no one but an attorney can give legal advice, and that includes us. We cannot give legal advice, legal opinions, or interpretations, but we can do the work for you at your specific direction. So one of the things that you learn to do along the way is ask questions to help your clients to think about what the right decisions would be, and then they give me the answers that I need. The legal document assistants that have experience, such as me, most of us have been paralegals in the past. Some of us have been court clerks. Some of us have been have worked with escrows. Excuse me. So the newer paralegal or legal document assistants come right out of school, paralegal school, most of them. And so the two pathways to become a legal document assistant are either, to graduate from an accredited paralegal school, or to have worked with, with an attorney for 2 years. Pardon me. Pardon me. Okay, I wasn't anticipating that. Okay, next slide.
Okay.
So, Josh, you want to take it?
Yeah. So basically, we're going to cover, there's going to be 4 topics here: understanding estate planning, the key elements of an estate plan, estate planning strategies, and then Jeannie's going to talk about revocable living trust. And what I would say is as we're going through this, and Jeannie's covering all of these topics, we're going to go through it. We're trying to keep it within that 30-minute range to respect your guys' time. Maybe give you some time to go and eat lunch also. But if something comes up, if you have a question, please pop it in the chat. And at the very end, we'll take a few minutes and run through some of those questions and try to answer those at the same time. And without further ado, we're going to jump right in. Go ahead and take it away, okay. Jeannie.
Thank you. So everybody has an estate plan. You can either do nothing, or you can do something, or you can do what's right for you. So next slide. Your estate plan will impact how you pass your assets on to your heirs at death, and how your needs are met in the event you become incapacitated. Next. So a good estate plan is written to meet the specific needs of an individual or family. And if there's one thing I've learned along the way, it's that no two people or no two families are alike. Some of them have very simple dynamics, others are blended. We have business interests that play a role in many of them. Some have special needs children that have to be given special consideration when they're made beneficiaries of an estate plan. Other people have other family considerations that will all weigh in. So it's really important to know that this is not a cookie cutter way to do business. This is an opportunity to address the specific needs of your individual self or your family. Next. So one of the questions I'm often asked is a will important? So the primary purpose of setting up an estate plan is to avoid probate when you die. And so a will is important. The purpose of a will is to tell the probate court how you want your assets distributed and who your executor will be. One of the questions I'm asked often is, I have a will, is that enough? And many people think that a will avoid probate, but it does not. So the process of probate, which is to either prove your will or to provide a state-provided statutory will if you die intestate, which means without a will. So yes, a will is important, but it's not always the complete package. Next. So the question I get often is, do I need a trust or do I need a will? Or do I need anything at all? And it could be any one of those questions could be the right answer. For people that don't have assets or have liquidated and used up their assets throughout their life, they may not even need a will. It just depends on how they have positioned themselves. If you have assets, an accumulation of assets worth $185,000 or more, regardless of the debt that is against those assets, you are, when you pass away, you will fall into a full probate. So that's the defining amount this year. It's set by law and it changes. This year it went up a little bit. And so if you own property, basically in California, you have a probatable estate. And so in most cases, a trust is the way to go. Next. Okay, so I just mentioned this. Do I need a trust? The primary reason to put your assets into a trust is to avoid probate when you die. But there's another time in life too where your trustee of your trust behind yourself would be asked to act, and that is if you became incapacitated. And incapacitation is not something that we think about every day or often do we plan for. But when you set up a trust, those two occasions in life, either at incapacity or at death, is when the people that you choose to represent you will step in and act on your behalf. And during incapacity, they'll pay your bills, they'll see that your needs are met, and whatever else you would do for yourself would qualify them to do for you. And then at your death, their job is to carry out your wishes as stated in your trust and to distribute your assets as an executor of your estate, called a successor trustee, to your beneficiaries and to close out your trust. Next. So I talk about probate. Why avoid probate? So what probate is the legal process of settling your estate through the probate court system. If you have a will, the probate process will prove your will and distribute your assets to your beneficiaries according to the terms of your will at the conclusion of your probate. If you do not have a will, the state of California has an intestate law for the distribution of your assets as stated in the probate code 6400 through 6414. And it's a logical process. They look for your next of kin, first children. If you don't have children, then parents, If your parents are no longer living, then siblings, children of your siblings, and so forth and so on, so they can find a person who qualifies to inherit from your estate. Whether you have a will or don't have a will, the probate process is identical. And one of the reasons, well, there's 3 reasons to really avoid. I think it's in the next slide. So probate is a public process. That means your private affairs become public for anyone to see. And I do probates for people that don't set up trusts. And it's a long and arduous experience. Probate is expensive, particularly as compared to the cost of setting up a trust. Attorney's fees are set by statute. So it starts at 4% of the first $100,000, 3% of the second, 2% of the third, and 1% of the fourth $100,000 value. So if you hire an attorney to do a probate, under the law, they can charge a $10,000 statutory commission or fee that is approved by the court to probate a house worth $400,000. If your estate is worth more, the price tag goes up. It's all set in law. The other thing about probate is it takes time, and the beneficiaries are the last in line. I state that it takes a minimum of 12 to 18 months, and that's been my experience, in large part because the court calendar is very crowded. And as an example, in Sacramento County, I can't get a hearing scheduled for 4 to 5 months. So, and there are 2 hearings in a probate, one at the beginning and one at the end. And in between, there's also a 120-day waiting period for anybody to make a claim against the estate. So there's your 18 months in Sacramento County. Placer County is not so bad, but maybe a month earlier. And it's kind of that way all up and down the state. So we want to avoid probate to avoid the cost, to avoid the public process, and to avoid having it take an enormous amount of time. And again, the beneficiaries are last in line. They get to inherit after every else has been paid, all the debts, the taxes, everything else, and then the judge will approve them for their distribution. Next. So let's talk a little bit about a revocable living trust. And I would say that 90 to 95% of my clients are trust clients. There are different kinds of trusts. There are revocable trusts and there are irrevocable trusts. And today we're going to talk about revocable living trusts. So a living trust is a document. Everything that we're talking about is document-based. It's a document that allows you to control your assets while you're still alive and to distribute them at death to your beneficiaries without going through probate. A living trust can be revoked or amended at any time during your lifetime. You are in control. You continue to be in control of all your assets, just as you are without a trust. As long as you have mental capacity, you have the ability to handle your affairs as you always have. A revocable living trust becomes irrevocable once you die, because only you can make a change to it and you're no longer living. It also becomes irrevocable if you are declared mentally incompetent by a written statement by a doctor, so that someone else can't come in and, change things that you would not change. So it becomes irrevocable at that time. So a trust only protects what it owns. And I like to equate it to purchasing a safe. If you buy a safe and put nothing in it, it protects nothing. If you buy a trust and put nothing in it, it protects nothing. And so it only protects what it owns or what you put in it. And the way you do that is through changing title to your assets once the trust has been established. And using property as an example, when I did Josh's trust for him, we prepared among the documents a trust transfer deed that took title out of their name as individuals, the title back into their names as trustees of their trust. That got recorded, and that is what protects their house from probate. And you go through a similar process for your liquid assets as well. Next, please. Okay. Well, I guess I got ahead of myself there. So yeah, you put your assets into a trust, as I just stated. So let's go on.
Okay.
Yeah. Okay. There are three positions or three people or persons within a trust. There's the trustor, sometimes called the grantor or the settler, depending on the preference or the software program that we use. I like the term trustor because I think it's more in line with what it describes. So the trustor is the person or the people that own the assets that put them in the trust. The trustor is the only person that can amend the trust or revoke it. The only time I've ever had trust revoked is when I did a marital trust and the couple divorced. So they went their separate ways. Their marital trust got revoked as assets got distributed, and then they got their own individual trusts. The second party to a trust is the trustee. And the trustee is the person that you name to manage and administer your trust. And my clients, 99% of them are well and can handle their own affairs. Sometimes the very elderly will have a child be their trustee, but most of the time the trustor names themselves, couple names themselves to be trustees so they can go on in life and manage their assets as they always have. And the third party to the trust is the beneficiary. During the lifetime of the trustor, so in Josh's case, during their lifetime, they are the primary beneficiary of their trust. The trust exists for their benefit, so they are all parties to the trust as long as they're well and living. In a trust, you then also name your ultimate beneficiaries, and those are the people that will inherit from you after you pass away. You also, in a trust, name successor trustees, and these are the people that would step in, as I had mentioned earlier, to distribute your estate, settle your estate after you pass away, or to take care of your affairs for you if you became incapacitated during life. Next.
All right, questions and answers. Let's see if we have anything. If you guys have any questions, feel free to pop them in the box here. So I've got one question here for you, Jeannie. Is there another way to avoid probate besides setting up a trust?
You know, there are ways, and sometimes a trust isn't the answer. An example could be someone who does not have a lot of assets. Thinking of one client who just had Social Security in a little house, and she there is a transfer upon death deed that can be used. That law is kind of fluid. It's a deed that I've used from time to time, because that's, in this particular client, that's all she had was a house. And so she wanted to maintain ownership of that house during her lifetime, but upon her death, there's a beneficiary designation that states who gets the house when she dies. So there was no probate because she had no other assets. Sometimes people will think the right thing to do is to put their child on as a joint owner of their assets. And that will avoid probate if all your assets are in a joint tenancy relationship. But there are some definite downsides to doing that. One is that when you add someone on as a joint tenant, either on title to your property or on the ownership of your bank account, your investments, you have given them as much ownership right as you have. So what that means is, number one, if you change your mind and you want to take them off, you can't do it if they don't agree. They now have as many rights to that asset as you do. Secondly, if that person has any kind of legal difficulty, causes an accident, causes an injury, and they get sued, and the other party prevails, they can take your asset if their name is on it, because they're as much an owner of that asset as you are. So joint tenancy outside of husbands and wives is something not to enter into lightly. So those are the other thing with joint tenancy too, is when particularly with appreciating assets like real estate, when you pass away, when you leave assets to someone at death, it gets a step up in the cost basis. And that means that it gets evaluated at the time of your death, and your heirs get a fresh start, a clean slate. So using property as an example, if someone bought a house 40 years ago and paid $80,000 for it, and today it's worth $600,000, they have a lot of growth in that. That's subject to capital gains, even after they take out their home ownership exclusion, about $250,000. If they gift that property during their lifetime, that cost basis goes with that gift. However, if you gift the property at death, it gets a step up in the cost basis based on the appraised value at the time of death. And so that $80,000 property cost basis now becomes $600,000, and the heir can sell that property for the appraised value or less and walk away paying no capital gains tax. So with joint tenancy, you've in effect given 50% of your property away during life, and therefore you've cut your step up in the cost basis in half. And it doesn't hurt you, but it hurts your beneficiary, who then, if they were to turn around and sell it, they would have half the property valued at an $80,000 cost basis and half the property at $600,000. So you can see you've taken a benefit away without really realizing.
Yeah.
So in most cases, if you have real estate or if you have liquid assets worth over $185,000, a trust is the way to go.
Okay. I have another question in here for you. How often do you recommend revisiting your trust once established for updates and amendments?
That's a good question, because when you create a trust, the document is good for life. So if your decisions haven't changed, then theoretically you don't have to make any changes to your trust. And your decisions are your people decisions. Who's going to be your beneficiaries? Who's going to be your trustees? Are the two big ones. You can buy and sell, add and remove assets from the trust every day. And you don't have to change the trust. You just have to make sure that when you buy assets, you title them properly. And Josh, you probably know you can sell property right out of a trust, and there's no difficulty with that whatsoever. However, from time to time, circumstances change, and so I think it's a good idea to look at your trust annually. And one of the big changes that's happened over time, when I first started doing this work, it was very common for married couples to have what we call a bypass trust or an AB trust, because it doubled their exemption from the unified tax credit, which is the federal tax law that allows you to pass so many assets onto your heirs without being taxed. In California, we do not have an inheritance tax, and it went to the voters decades ago, and it got written into the Constitution that we will not have an inheritance tax in California. So that's a good thing, but everybody's subject to federal estate tax. When I first started doing this work, it was $600,000 per person. And so, as you can imagine, in California, with the prices of property, it's not hard to be worth $600,000. So everything above that would be subject to federal estate tax. So with a married couple with an AB trust or a bypass trust, they were able to double that exemption to 1.2 million. But it puts restrictions on the trust at the first death. And so there have been better products that have come along that allow you to consider having that dual trust at death, because part of it becomes, half of it becomes irrevocable, or not to consider it. So a lot of the restated trusts that I do are getting people out of the AB trusts. They don't even realize they have it much of the time, so that they have greater flexibility and they don't have the rigidity of how to handle your affairs after the first death. So I would encourage you to review your estate plan, make sure that your ex-wife isn't, your beneficiary or something like that.
Yeah, for sure.
Yeah.
Okay. And so I've got a couple more that popped in here. Can trust laws change over the years or might change? I guess, will they change? I guess was the...
Well, there are elements. So if you set up a trust, trust law has been pretty stable for thousands of years. Trusts have been around for a long, long time. There are two things to know. One is that every legal document has to have a start date and an end date. So the start date is the day you sign it. That's the effective day. And even if you modify and amend your trust, even if you do an amendment in full, the name of the trust and the date it was established never changes. So I've been working with a lady now who she's actually gone through a name change because of being a widow, remarrying, but she had a trust under her own under her former name. So we can address those issues. But the name of the trust and the day she originally signed it will never change. So so in the years that I've been in doing this work, trust law has not changed to the extent that it would nullify your documents. But there are elements within it. A big one is this unified tax credit. And those are acts of Congress. How much money should we allow people to pass on to their heirs without taxing them? And what was once $600,000 today is $12.9 million. So there's a huge change, but it's to the advantage of you and me, basically. I can tell you, I do not have a client who has a taxable estate because my clients all fall under $12.9 million. So to answer your question, there is nothing that I can think of that would cause your estate plan not to be legal. Even if you wrote it 20, 30 years ago, if you want to be sure, you could sit down with an attorney and have them look at the law with you. And because I can't make a legal interpretation, and then you will have a good idea. But yeah.
Okay. I've got two more questions. If a spouse predeceases, how does that change the trust?
Okay, good question. Most marital trusts name the husband and the wife as co-trustees of the trust. And in the language of the trust, it'll say, if one spouse dies, the other spouse remains acting as the sole trustee. And that works for most people. For really elderly people, like 80s in their 80s or 90s, sometimes it becomes too big of a burden, and they will have one of their children step in and co-trustee with them. But aside from that, one spouse dies, the other spouse remains on as the ongoing trustee. There are some steps that should be taken at the first death to just really update things. One is an affidavit of death should be recorded to remove the deceased's name from title. And so in doing so, then the remaining trustee, the surviving spouse, would continue on title. The trust doesn't have to be updated per se, but there is a document that is part of the estate plan called a certification of trust. And that should be updated, because then you can use that to update bank accounts and get the deceased's name off of title on the bank accounts. If you never do those things, it will be done at the second death. So, just know that there will come a time when your successor trustees will have to deal with this. So a couple steps along the way at the first death will make things easier for them in the long term.
Okay. I actually just had another question pop in. So we're a little bit over, but I want to get these answered if we can.
Well, I have the time if you have the time.
Okay, so question is what is a typical fee for a trust for a family of four? You mentioned software. Trust can be done online with softwares, question mark, or better in person with qualified personnel.
Well, I have seen a lot of software trusts online. LegalZoom is probably the one that's known the has the it is known the best. They're not great, and that's not just my opinion, but you'll find that throughout the legal profession, because for one thing, many of them don't take into consideration laws that are specific to a given state. And so, yes, you can do your own trust and do it for very little, just the cost of buying the software. The quality of it runs the gamut, and I have redone many of these trusts. Sometimes because people answer questions, but they're not really understanding. They're not having a conversation. But an example of, and I'll get to the costs in a minute. An example of that would be sometimes people. One of the questions I ask is if one of your beneficiaries dies before you, do you want their portion to go to their heirs, or do you want it to go to your surviving beneficiaries? And they'll say, oh, I want to go to the rest of my kids. And I'll say, okay, fine, I'll do it that way. But what you're doing is by doing that, are you aware that your grandchildren will get nothing? And you go, oh, well, let me think about that. So in asking questions, people think a little more deeply. When you just do a software program online, you're just getting a generic boilerplate program, and a lot of them are no good. So the cost of doing a trust, most law firms will, if you're single, somewhere around $2,500 or so, sometimes more. Marital trusts are more because there's more work involved. So it's not difficult to spend $3,000, $4,000, $5,000. I charge $1,100 to do a single person's estate plan that includes the trust, the will, power of attorney, all the healthcare documents. There's some other peripheral documents that go with it. If you have minor children, guardianship documents, your trust transfer deed for your home. I do charge extra for extra deeds. I charge a $150 extra for additional properties because deeds take time and they have to be perfect. For a marital trust, I charge $1,500, and that's a flat fee. I take half my fee up front and half at the end when the documents are completed and signed. I'm a notary, so I include my notary fees. I don't charge extra for that. And I can notarize all the documents except the pour over will, which needs to be witnessed by two people. I can be one, and I ask my clients to come up with the other one. Okay.
Awesome. Okay, another question. So in the event, I'm just going to kind of paraphrase this. If you, Jeannie, were to put together a trust, and a client chooses to work with you, but you pass away or you get out of the business and they need to amend that trust, like, do they have someone that's on your team that they can go to, or can they take it anywhere? How does that work?
That's a great question, because I have done updates of trusts of people that have died, attorneys that have died, basically. I belong to the California Association of Legal Document Assistants, and that is our professional association that is statewide. And you'll find, if you ever go on their website, it's CALDA, CALDA.org, that there are lots of other areas of law that legal document assistants work in, like family law, and lawful detainers, immigration, all of. I stick to what I know, which is estate planning, probates, and trust administration. So you can take a name off the website. I have local colleagues that I know that I could give you, and I have done this, their name and phone number if I was not available, and if I died, because I choose someone younger than me, so the chances are that they would outlive me. But yeah, there are other qualified people that could definitely pick up the ball and run with it for you and make any amendments that you would need to make.
Okay, awesome.
And then I do have part-time help, but I don't know if that person will ever do this as a profession. They do help me on some of my administrative side, but yeah.
Gotcha. Okay. And oh, hold on. Just okay. So this one popped up. I live in North Carolina. Could you be my lawyer or should I get someone local?
Get someone local.
Okay.
I mean, my software program is state specific. I could do it, but I think you'd be better off getting forming a relationship with someone who you can look in the eyeball and who can help you.
Would you happen to be able to refer them to someone in North Carolina? Like, do you have a network you can refer to?
I do not have anyone outside of California that I can refer to.
Okay.
Except for maybe Nevada, because I do some cross state stuff with them. Yeah.
Gotcha. Okay.
But check and see if you don't have a an association like what we have in California, where they could give you a referral. Another place to check too, interestingly enough, I get referrals from the probate court because I push, when you push enough work through there, they get to know your name and then you get to know the quality of your work. And so you could even check with a local law library or with the probate court in your county to see if they have someone they can refer you to.
Okay. For that last question, I actually have a couple realtors in North Carolina, and I would imagine they probably have some connections as well. So I'll contact with them to grab that info. Last question is, what is the biggest mistake that people make when setting up a trust?
That's a great question. The biggest mistake they make is not funding it. So going back to what I said about putting assets in a safe, I'm doing a probate now, and I'm not going to be doing two, where not all the assets were put into the trust. And so even though part of the trust, a part of the estate was protected by the trust, these assets were not, and I'm having to do a full probate on them because they're worth over $185,000. There is an action called a Hagstead petition that is an option. It's still a court action, but I've been able to file a couple of Hagstead petitions over the years that prove to the judge that these assets should have been in the trust, and the judge allowed it. But short of that, you're looking at a full probate if you don't put your assets in the trust by properly retitling them. And also know that any asset that has a valid beneficiary designation at the time of your death is not subject to probate, and therefore is not subject to the terms of the trust, and will go directly to that beneficiary regardless of what the trust says.
Awesome.
Yeah.
Very good. Okay, well, that wraps up our questions. We are slightly over time, but we have some really good questions. I want to make sure we get those answered. So I'm going to kind of close things up here. In conclusion, we have a little bit better understanding, thanks to you, Jeannie, on what it means to have an estate plan in place. We went over some key elements of an estate plan. We talked about estate planning strategies, and we even discussed revocable living trusts. So I just want to take a minute and thank everybody for being here on this call. Thank you for your participation. Thank you for your questions. And I just want to encourage you that if you have not put a trust in place, to take the time and get the information, educate yourself a little bit more. Obviously, you've got Jeannie here who you can reach out to, and get any more questions answered if you have that, and or you feel free to reach out to me if you need a contact. If you're out of state, between the two of us, I'm sure we can help you get that part covered. I'm a big believer in sharing is caring, and just ask that, if for both Jeannie and I'm in the real estate business. Jeannie does all of your legal doc prep. And so if you know of anybody that needs these covered, whether you're looking to buy or sell, or whether it's this year, next year, 5 years from now, whatever that is, please share our information. And here is our contact. Also, just so you know, this is being recorded and we will send this out so you can revisit it if you need to grab any information. And I just want to close out with Jeannie's disclaimer. Again, she's not an attorney. She can't give legal advice or represent you in court, but she can help self-help services at your specific discretion. So thank you all. And thank you, Jeannie, for taking the time.
Josh,
Yes. Oh, yes. Yeah. No, thank you very much. I appreciate it. And until next time, maybe we'll have a 201 or something down the road. But everybody have a very blessed day, and I will talk to you all soon.
bye. Thanks, everybody.
Let's see if I can stop sharing that. And